Call the roll.
Representative Cragel,
Here.
Representative Chestick,
Here.
Representative Harrelson,
Here.
Representative Jennings, Representative Nemec,
Here.
Representative Provenza,
Here.
Representative Rodriguez Williams,
Here.
and Chairman Washut.
Here.
Amber Oakley is present as well.
Who did I miss?
Ember Oakley, Representative Oakley.
Oh,
We're working the kinks out this morning.
okay. Sorry about that. Thank you for that.
All right. Well, thank you, committee, for being here promptly on time this morning, and welcome to our few visitors in the room today. We have a couple bills that we're going to move through, I think, fairly expeditiously. And so we have House Bill 9 and House Bill 13 that we will consider this morning. Just a few preparatory comments. Please turn off your cell phones and devices so that we don't have interference during the meeting. Remind myself as well. Also, if you have a fairly substantive amendment that you want to offer on any of these bills, please make sure we give copies to the secretary and the committee members before we get going here. If you need to have copies made, copy centers across the hall, and Ms. Sandy Dent will assist you. The meeting is being streamed live. Are we up and streaming? Good. So when you testify, you'll need to press the button until the little green light comes on the microphone, then speak loudly and clearly so that people in Zoom land, as well as the committee and those in the room, can hear your testimony. The bills today are committee bills, so we will present them ourselves and then hear other testimony from anybody, state agency folks, other legislators, representatives of interested organizations, and members of the general public. When you testify, we ask that you state your name. And if you're new to this committee, please spell your last name for us so we can get it in the record correctly. If you are representing an agency or an organization, please identify that agency or organization so that we know who you're with. If you're a private citizen representing yourself, please tell us where you reside in the great state of Wyoming. Online folks who wish to testify should raise your hand and identify yourself as wanting to testify at this time. And we'll create the list at the start of the meeting for those wishing to testify. And also let the tech folks know which bill it is that you wish to testify on. Do we have anybody online yet? No testify? Okay. All right. So we'll begin with House Bill 9. House Bill 9. So for those in the room and those who were not with us during the interim, I'll walk through the bill, give a kind of a synopsis of what this bill entails and why it is before us. It's the history of the Judiciary Committee to periodically review decisions of the Wyoming Supreme Court. And it's not uncommon for the court to mention in their opinions that things might be a little more clear in statute, or a particular statute could be interpreted a couple of different ways. And we try to address those within the Judiciary Committee. And this is one of those bills. House Bill 9 deals with the concurrent jurisdiction of juvenile courts. And the background on this case is you have a young person who's 17 and 2 months old when he is alleged to have committed the crimes of third-degree sexual assault and felony crime of restraint on the individual. And thus, an investigation occurs, but he's not charged until after he turns 18. And then we have this situation where we have an adult who committed a crime as a juvenile. And the question before the court was whether or not the juvenile court would have concurrent jurisdiction in such a case. And the district court ruled that the juvenile court did not have concurrent jurisdiction, and the Wyoming Supreme Court took a different opinion to it. And now we're here today to try and perhaps codify in statute what the court ruled in that opinion, that the juvenile court does have jurisdiction, that the determining factor is the age of the individual at the time the crime is committed, not the age of the individual at the time the individual is charged. So if you look at your bill on page 1, line 13, we get into the substance of the bill. We're amending Wyoming Statute 14.6.203C. And what we're clarifying there is that the juvenile court does in fact have concurrent jurisdiction in all cases other than status offenses. Status offenses being like minor possession of alcohol, possession of tobacco, those sorts of things. And then on page 2, line 1, a minor is alleged to have committed a criminal offense or to have violated a municipal ordinance. An adult, and then on line 4, an adult is alleged to have committed a criminal offense or to have violated a municipal ordinance while the adult was a minor. So there's no fiscal note, there's no financial impact on this bill. And that's the topic before us today. Is there anyone wishing to give public comment on this bill today? Director Schmidt.
Good morning, Mr. Chairman, members of the committee. My name is Corinne Schmidt. I'm the Director of the Department of Family Services. As you mentioned, this is an interim bill. We haven't had any concerns, but I wanted to be available for questions if needed.
Are there any questions for the director? We do appreciate you getting up early and being here with us this morning. Thank you.
Absolutely, Mr. Chairman.
Anyone else in the room wishing to testify, please come up. Make sure the green light's on.
Morning, Mr. Chairman, members of the committee. My name is Beth Lance. I'm here today on behalf of the Wyoming Child Lawyers Association. I don't have much to say except that our membership supports this bill. It certainly is exactly what Mr. Chair, you just described, which is that the Supreme Court made this finding in a case, and we appreciate that it's being clarified and codified into law so that it's clear for all our practitioners as to how this will apply moving forward. And I would stand for any questions.
Thank you, Ms. Lance. Any questions for Ms. Lance? Representative Oakley.
Thank you, Mr. Chair. Good morning, Ms. Lance. So my question to you, I plan on bringing an amendment. So with that, but I would like to get your opinion on it. So currently the bill says, changes it to, or clarifies it, says an adult is alleged to have committed a criminal offense or to have violated a municipal ordinance while the adult was a minor. I would like to significantly limit that to somebody, basically 18, 19, 20-year-olds. So after, you know, so which specifically this Rosen case was about, right? Like as the chair said, so 18 years old when charged, 17 years old when committed the offense, which is what Rosen looked at. But if we don't clarify and keep it to that 18 to 20-year-old, I think we broaden it too much, because a juvenile court can't do anything with somebody who's over 21. I don't think there should be jurisdiction. Of course, this would be concurrent, but also there's just nothing to be done. They can't be incarcerated. They can't be. So that kind of makes it a meaningless area. So I think that's going too far. So I was just wondering, I guess, what you think about that. Would you be fine with narrowing it that way?
Ms. Lance?
Mr. Chairman, Representative Oakley, no, I wouldn't feel that such an amendment is necessary, and that is because it is just concurrent jurisdiction. And in my experience, if there are reasons, depending on the crime or depending on what's occurred, even if they were a minor, those cases are handled and charged as an adult and handled in adult court. And that's still currently in action. This just allows that concurrent jurisdiction when they were a minor, when it was committed. I certainly understand what you're saying, Representative, that if, we don't have statute of limitations on crimes in Wyoming, so someone could be 40 and their crime was committed when they were 17. But obviously, because of that being concurrent jurisdiction at that point, that would be handled in adult court. I think that this codification and the way that this is written doesn't prevent the court from handling it in that manner under those circumstances.
Representative Oakley, follow up?
Thank you, Mr. Chair. So if I'm hearing you right, Ms. Lance, though, can you give me an example? And this is good discussion, thank you. But so if it can, you said it could be handled in adult court, but so my question still exists that then that creates either an absurd or an unnecessary, in this case, concurrent jurisdiction, which could then, for example, make it so that like a transfer hearing had to occur. A defense attorney could handle that, which could require that, and that is an unnecessary step. To me, when it's more clear, if that's the case, it could, as you just used the example, that it would be handled in adult court, then why wouldn't we just make it so legally that's the only place it can go? So if you have any further comment on that, because I agree it's concurrent jurisdiction, but all the more reason if we don't think that somebody over 21 can be handled in juvenile court, then why would we statutorily allow it?
Ms. Lance?
Thank you, Mr. Chairman. Representative Oakley, I think I see what you're saying. You would be limiting the amendment to anyone who at the point of time that they were charged, they were 21 or older. Is that, that may be acceptable to my membership. I would certainly want to take it back. We had 3 or 4 people. We had a discussion yesterday on this bill that were very interested in this bill and were involved in Rosen. And so I would certainly want to be able to take that back to them, but that may be something that we could support, and I will definitely ask.
Any further questions for Ms. Land? Thank you very much.
Thank you.
Anyone else in the room wishing to testify on this bill? No one on Zoom? Very good. We'll close public testimony. Committee, what's your pleasure? Representative Chestick? Press the button until the green light comes. There you are.
Mr. Chairman, I have a question about the bill, and it might just reflect my
We need to bring the bill to the committee first, and then we can have a discussion. So Representative Provenza, second by Representative Oakley to bring the bill to the committee. Now your question, Mr.
Okay,
Yeah.
Mr. Chairman, thank you. Yes, I'm confused about line 15. I know it's not part of the amendment, but other the qualification other than status offenses. Am I correct in that status offenses like underage drinking, stuff like that, are currently not under the jurisdiction of the juvenile court? Because that would continue under the amendment that those kinds of status offenses there would be no concurrent jurisdiction, would always be in adult court. Is that my correct understanding?
I'll refer to Representative Oakley. Maybe she can fill us in on the status offense situation.
Thank you, Mr. Chair. I mean, it wouldn't take long, but I don't have it in front of me as far as why why it already exists in statute that it says other than status offenses. I think because, actually, I bet. Do you all know? Kara? Like,
We've closed public testimony, unfortunately, so we're gonna have to wrestle with this one up here at the dais, so.
Okay.
Yeah, the best I can say is that's existing language
mhm.
in the existing statute. So we're not changing that.
Right, we're not changing it. I'm just wondering, should we? So what is the rationale for having status offenses always go to adult court? I'm not sure that that's a good thing.
I don't believe that they always do go to adult court, but how this fits into the statute existing, I am not able to testify, but let's make an exception and go ahead and have Ms. Chambers come up if she can clarify this for us.
Thank you, Chairman. Kara Chambers, Division of Victim Services, Attorney General's Office. I apologize. Was not planning to be here for this. Walked in as you were asking the question. But I'm just going to give an overarching statement. So status offenses are categories of offenses that are only punishable due to the person's age. So you can only be, held accountable for a status offense under the age of 18. So I didn't catch what you were referencing, but my overarching understanding is they're carved out because they are the special status offense. I can tell you in practicality, when I have worked with licensing boards and we look at prior convictions, we do not consider status offenses. So it's treated differently. I'm not sure where you saw that they always go to adult court. Again, I don't practice in this area per se, but my understanding is if that's the case, it's because they're somehow not really a juvenile case. They're not really an adult case. It could just be a matter of how these things are handled. But again, didn't hear what you cited.
Okay.
Don't have it in front of me. Just giving you an overarching, my experience. Representative Jennings, welcome back. You're used to me doing this kind of stuff. So thank you. Good morning. And I will stand for any questions.
Any questions for Ms. Chambers?
Hey, Mr. Chairman.
Mr.
So
Representative Chestnut.
my question was, under existing law, this section gives jurisdiction to the juvenile court, and it says the juvenile court has concurrent jurisdiction in all cases other than status offenses, which means that status offenses, the juvenile court, the way I read it, juvenile court does not have jurisdiction in status cases. So a 17-year-old is caught drinking and is charged with underage drinking. That's going to go to adult court, it sounds like, and that doesn't sound right to me. And that's my question. Do we have a problem with that? Is that something-
Representative,
Go ahead.
I think there's another possibility. It would be that the juvenile court has exclusive jurisdiction on status offenses. So while they may not have concurrent jurisdiction, they may have exclusive jurisdiction. And I'm not clear on whether that's the
Okay.
case. Ms. Chambers?
Chairman Washit, Representative Chestnut. I would concur. I don't have it
Okay.
in front of me, but that is existing law and you're correct. It just says concurrent jurisdiction. It doesn't say exclusive. So it could be the latter. And I don't have the full
So
statutes in front of me.
the answer is probably in section.
Representative Chestnut?
I'm sorry. Mr. Chairman. So the answer is probably in sections that aren't being shown up here on this bill. There's other parts of the statute that cover this probably.
Representative Craigle?
Thank you, Mr. Chairman. We're really talking about two different court systems here, right? So status offenses go through circuit court.
Right.
And because they're misdemeanors,
Thank you.
the juvenile court typically handles more serious offenses. And so that's why the concurrent jurisdiction deals not always, but mostly with felonies. And so you're talking about this actually the same judge in district court, which is juvenile. and they're going to handle the felonies, whereas your status offenses, that's why they run through circuit court, or oftentimes they're running through municipal court. And so that's really the carve out there.
Okay, thank you. I appreciate that.
Representative Nybeck.
If agree, well, just let me know if have this right. A underage drinking as well as possession of tobacco is not a status offense. It's a criminal offense. Running away is a status offense. Is that not correct? Thank you.
Chairman
Chambers.
Washit, any crime that is a crime due to age is a status offense. So minor in possession is a status offense. Purchasing tobacco under, which I believe is now 21, would be a status offense. There's several status offenses. I don't have the whole list, but again, the term status means because you're status, because you're of a certain age. And those are status offenses. So there are probably several. I can't off the top of my, I think we hit the highlights that I'm thinking of, having been a teenager once.
Thank you, Ms. Chambers. Anything further from Ms. Chambers? All right, we will once again close public comment. Bring it back to the dais. And committee, is there any further action? Any proposed amendments? Representative Oakley, do you have your amendment?
Yes, Mr. Chair. So I would like to make a motion for an amendment.
Go ahead.
So it's 2, right? Page 2, line 4. It says an adult is alleged. So after adult, I would like to add who has not reached the age of 21.
Second by Jennings. Secretary, do you have that amendment recorded? So on line 4, after the word adult, we're going to insert who has not reached the age of 21. And then continue on, is alleged to have committed a criminal offense. Everybody clear on the amendment? Discussion on the amendment. Representative Oakley.
Thank you, Mr. Chair. So obviously through my questioning, there's been some discussion, but just for the committee's sake, so the Rosen case was what was the impetus for us to be hearing this bill. Specifically in that, the Supreme Court noted that Mr. Rosen was charged when he was 18, an age over which the Juvenile Justice Act contemplates juvenile court jurisdiction. Again, so why we're looking at it, because there was that gray area. But then it goes on to say this case does not present a question of the juvenile court's jurisdiction over a person who commits an offense as a child and is charged after he reaches the age of 21. And we therefore will not address that question. So it specifically even talks in Rosen that that was in that 18, 19, 20 when they're over what is considered an adult, but not the adult over 21. There's different categories there. And so I think, it said it wasn't going to address that, but I think we should address that. And I think this simple amendment clears that up. And I personally would say, I think it's important to do because I've just used an example. We have, there's a case in Fremont County, and it actually isn't about a juvenile, but just using it as a hypothetical. So where, let's say a 17-year-old did a molested or a sex assault on a 7 to 9-year-old, because this is using a case that we've had, then it was high school before the child started talking about it. 17 years old in high school. So 10 years later. So now that person is 27 years old. And often that's what you're going to see in my estimation of a case that's brought years later. If it's a small matter, you're not going to the prosecutors are just not going to go resurrect something for a simple matter. So that's what you're looking at. So that, well, okay, this person, it may be a pedophile kind of a thing. This is a harm to the community, so we're going to charge it. There would be no reason to have concurrent jurisdiction for the juvenile courts at that point, zero. At most, it could just create an unnecessary hearing. There would be no way to handle that person through juvenile court. They're over 21. It creates an unnecessary, I mean, possible absurdity. That might be a bit far, but certainly unnecessary. So I think when you take the Rosen case, which is what we brought this, but also noting the Supreme Court said we aren't touching that over age of 21. So we brought this bill, but it doesn't address that. With this amendment, it gets both. So I think it's appropriate in the law. I think it's an appropriate amendment. So I would ask for your favorable consideration on it.
Further discussion on the amendment? Representative Craigle.
Thank you, Mr. Chairman. And this is just, I guess, thinking about that, do we need to distinguish between, and I cannot remember the the language used within the Rosen case, but do we need to distinguish between under 21 and 21 and over? Because there's a gap year there, right? I mean, and so I don't know the right answer to that, but are we talking about someone who has reached the age of 21, or does the jurisdictional, and I mean, we can pull up the statute, but we just probably should look at that real quick. Does the jurisdiction of juvenile court encompass someone who is 21 or someone who has to be under 21? Does that make sense? Because we're talking about that year of when you are actually 21 years of age.
Yeah, so I think it's once you reach.
Representative Oakley.
Sorry, Mr. Chair. I think I'm correct, so I agree we can check it, but I think the day you hit 21 is that fits. I don't think there's a gap year. So I think under the age of 21 fits, but it's also, we could also say if you're from the ages 18 to 20. But I think it's the same thing and would in the statute.
Further discussion on the amendment? Representative Provenza.
Thank you, Mr. Chairman. I guess some of my concern with this amendment, and I'd like to have more discussion with folks, maybe who would have various opinions or be able to kind of look at this more in depth and see what the consequence could be. Because I see Representative Oakley's point, and could see why the court didn't make that decision later. And I could also see concerns about the example that Representative Oakley gave. My worry is in the point of having a juvenile justice system and holding juveniles to a different standard is their state of mind at the time that they committed an offense. And so if you have a youth in a different situation that commits an offense that's maybe it's a product of being young, but is still serious enough, is it fair or does it make sense under the assumptions of our justice system to then hold them to that standard as an adult? I don't know that that is the purpose of our juvenile justice system and our statutes to consider people under the age of 18. So I worry about how this might be kind of narrowing this in a way that might be consequential in a negative way. But I'm open to more discussion about maybe what that could look like. But I think ultimately the problem overall, and that this bill doesn't touch, is that this is a Band-Aid for to fix for the Supreme Court, and that we have a bigger issue of how we look at youth offenders. How do we look at someone's state of mind for crime, and what is the appropriate punishment if our goal is to rehabilitate? So I'd like to maybe continue those conversations more in depth as we move forward. But for this, I just wanted to kind of share those thoughts in case anybody new on the committee is wondering maybe how to look at this.
Thank you. Any further discussion? So for my 2 cents, my thought is, what exactly would the juvenile court do with a 30-year-old person, right? So to me, it doesn't make much sense that we would not carve this out. I do find this question of are 21-year-olds included or excluded in the existing law to be a worthy question that we probably ought to get to the bottom of. So we'll call the roll on the amendment, and then we'll talk about if there are any other amendments. Madam Secretary?
Representative Grego, how do you vote?
Aye.
Representative Chestick,
Aye.
Representative Harrelson,
Aye.
Representative Jennings, Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Rodriguez Williams,
Aye.
and Chairman Washit.
Aye. And the vote total was,
We have a total of 8 ayes and 1 no.
so the amendment has passed. Are there any further amendments? All right, let's call the roll on the bill, House Bill 9.
That was on the amendment. And so this is on the bill.
Okay, Representative Cragel,
Aye.
Representative Chestick, Representative Harrelson,
Aye.
Representative Jennings, Representative Nemec, Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams.
Aye.
And Representative, no, excuse me, I'm sorry, Chairman Washit.
Aye.
We have 9 ayes.
With that, House Bill 9 as amended has passed Judiciary Committee. We'll move now to House Bill 13. Vice Chairman Rodriguez Williams. Want to walk us through the bill?
Thank you. Thank you, Mr. Chairman. Committee, I bring to you or introduce to you House Bill 9, titled Juvenile Courts. Wrong one, sorry. Bring to you House Bill 13, titled Office of Guardian Ad Litem Program References. This was sponsored by the Joint Judiciary Interim Committee. And essentially, this bill amends all references within the state statute from the Guardian Ad Litem program to the Office of Guardian Ad Litem. And so I'll walk you through the bill. We have several changes on page 2 where we strike the word program and insert office of and the word office to make that change. On page 3, line 13, we insert administered by the Office of Guardian Ad Litem. And on line 14, scratch the word program, insert the word office. And very similar changes throughout the remaining, the remainder of the bill you see before you.
Yeah. So for those in the audience, a guardian ad litem is a representative of a juvenile in legal proceedings appointed by the court to speak for that child's interests. A few years ago, we moved by statute the guardian ad litem responsibilities out of the state public defender's office into a standalone office, if you will. And as a consequence of that, we need to have conforming language within the rest of our statutes. These have been identified as some places where we were still referencing the old system of how we provided the guardian ad litem, and we're just updating the statute so that it currently reflects what we actually do with the guardian ad litem today. So with that, is there anyone in the audience wishing to testify on the guardian ad litem bill? Saying none, do we have any in Zoom land? None in Zoom land either. Committee, what's your preference? Moved by Representative Harrelson, second by Representative Craigo. Any proposed amendments? Seeing none, we'll,
Have some discussion.
any
Mr.
discussion on this?
Yeah,
Representative
just-
Jennings.
Just a question, Mr. Chairman. So is there any practical, I mean, what's the war on the word program? I mean, apparently we don't like the word program. So what's the real reason? What's that change?
In the new statute, as we moved from the public defender's office to the new office, we used that language, right? So we no longer refer to it as a program, and now it's an office. So it's just conforming so that it's consistent reference. It'd be like referring to any other state agency as a department in one place and as a directorship in another place, right? So we're just being consistent here. Any further conversation about this bill? Anything? Seeing none. Madam Secretary, please call the roll on House Bill 13.
Representative Craigo,
Aye.
Representative Chestick,
Aye.
Representative Harrelson,
Aye.
Representative Jennings, Representative Nemec, Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
and Chairman Washut.
Aye.
We have a total of 9 ayes and 0 noes.
And with that, House Bill 13 has passed Judiciary Committee. Thank you all. Good opening, getting started, getting used to the concept of going through the chair and keeping our conversation moving that way. But I thought we had a good first meeting. Remember, just a reminder to the committee, on Friday morning, joint judiciary will be meeting in the historic Supreme Court chambers. We will be receiving a briefing on fentanyl and the Wyoming State Crime Lab from the agency. And then when we adjourn from there, we will come back to our room and we will have one bill on Friday, which I believe is going to be the State Park Rangers retirement bill. So with that, House Judiciary stands